As we all know, the first speaker is Honorable Mr. Prakash Naik, sir, former judge of the High Court of Bombay. He will be sharing the invaluable insights on the preparation of criminal trial, strategic planning and practical approach. We'll be commencing very briefly. Dear participants, please be seated. We are starting with our first session for today. All the participants who are waiting outside the hall, please be seated. We will be starting with the first session. Dear participants, please be seated. And may I now request Vikhroli Court Bar Association members to kindly grace the stage. May I also request Honorable former Justice Prakash Naik, sir, to kindly grace the stage. We now have the distinguished privilege to felicitate Honorable former Justice Prakash Naik, sir. May I now request Nirbhavne, sir, to kindly felicitate former Judge, Bombay High Court, Prakash Naik, sir. Sir, it's been a great honor to have you with us here today. All the participants, please be seated. We are commencing with the first session. Justice Prakash Naik, sir, now retired, still continues to influence the legal community with his wisdom and vast experience in criminal law. His judicial legacy is reflected in his well-reasoned verdicts and lifelong contribution to the legal thought. Though off the bench, his wisdom flows. Where justice calls, his spirit grows. A sage whose legacy we prize, in every court his essence lies. Thank you so much, sir, for being present here. May I now kindly request Honorable Justice Bombay High Court, former Judge Prakash Naik, sir, to take the stage, and we are eagerly awaiting for your session, sir.
The members of the profession sitting on the dais, and all of you who are sitting in this historical convocation hall. I am glad that I got this opportunity to be amongst you and to participate in today's workshop. This is the place where I belong. As you all know, I was a lawyer practicing in Bombay High Court. Then in between I was elevated. Then I have again come back and joined this profession. The fact of telling you this aspect is that legal profession is the most challenging profession. There is no such challenge in any other profession than that of legal profession. That's the reason which prompted me to again come back and practice and be a lawyer amongst all of you. As we all know, in the past, the students used to join law only because there used to be some promotion or some increments, or there was nothing else to do. But now the things have changed. This has become a very dynamic profession. It's lucrative, it's challenging, it's competitive. There's a lot of competition. Many law colleges have been established. National law universities are established. Students study law abroad. So there is a lot of competition. There are competent people, competent students who join the law. And when I say there's a lot of competition, it also means that we all are required to be professional and competent enough to handle the matters and discharge our duty as a professional. A lawyer plays a very vital role in the society. A lawyer appraises the people of this country, the legal principles, advises the people, helps the downtrodden. The lawyers have participated in freedom struggle. The lawyers are everywhere. So the role of lawyers is very, very important. And it is expected that we not only should earn money, but we should also discharge our duties towards the society. A lawyer is called a professional because it is expected that a lawyer knows the law and would deliver the goods in the court. And that requires that you have to be competent enough to handle the matters of your client. The protection of your client is sovereign. Your whole goal should be to protect your client. Your whole motto is to see that you discharge your duty in fair manner. Today's topic is about the criminal trial, planning, strategy, preparation. So therefore, we are going to talk about the criminal lawyer. Legal profession, either civil or criminal, of course, it's tough. You can't take it easy. There is no easy money. There are no shortcuts. There is hard work. Either you practice in civil side or criminal side. There is no substitute for hard work. As a criminal lawyer, we are supposed to know the cardinal principles of criminal jurisprudence. With the knowledge of criminal jurisprudence, with the knowledge of law, criminal law, it is also expected and we must adhere to the professional ethics. A lawyer is supposed to be pleading for his client, and therefore, all the more expected that he knows the law, he knows the matter, he has read the matter, he has mastered the facts of the case, and then only he has been in a position to appear before the court of law. Some people feel that criminal law is easy, and there's a lot of earning, easy earning, quick earning. That's not so. Unless you practice criminal law, it's not possible for you to understand the finer intricacies or nuances of criminal law. A criminal lawyer has to master Criminal Procedure Code, now BNSS, Indian Penal Code, BNS, and Evidence Act, BSA, which is now has been brought into force. A criminal lawyer is expected to know the basic tenets of criminal law, the basic principles of criminal law, the jurisprudential aspects of criminal law. A criminal lawyer is supposed to know what is evidence. Today, me or no one can say that I'm perfect. Of course, there are many seniors who have mastered the art of conducting criminal trials. There are many lawyers who have been day and night appearing in the criminal courts. But according to me, none can say, including me, that I know the law or I know all the aspects of law. This is a profession where you keep on learning every day. Your colleagues teach you, your juniors teach you, your opponents teach you, the judges teach you, and even the judges are taught by the lawyers. My experience as a judge of the Bombay High Court is that there are many provisions of law, many aspects of law, many judgments, reported judgments, interpretations of law were not known to me, which were taught to me by the lawyers. So it all depends upon how the lawyer is well prepared, how the lawyer knows the law and is in a position to appear before the court, the result matters. Good judgments depend upon the good arguments advanced by the lawyer. You go to the reports, law reports, and find out all those celebrated judgments. Like Maneka Gandhi's case, ADM Jabalpur case, Keshwananda Bharati's case. All criminal judgments like on circumstantial evidence, burden of proof, criminal jurisprudence. Eminent lawyers had appeared before the court of law. It's because of the assistance of the lawyers the judges could deliver good judgments. So imparting justice is a process where the lawyer as well as the advocate are involved. A lawyer just can't say that I have done my job, it is for the judge to do the job. As I have said, the good judgment will depend upon how good you have argued the matter before the court of law. That is the reason it is expected that a lawyer should be well versed with the law. Before entering into the criminal court, what is expected before planning the trial? Let us first of all understand that what is expected of you as a lawyer, which is the first and foremost thing. And the second thing would be as to how you are going to plan yourself when you are conducting a trial. To be a good lawyer, as I have said and I am repeating, that you have to put up hard work. And how hard work? You have to be a voracious reader. You have to be an orator. You have to master the language. You should have good command over the language. You should have a strong vocabulary. You should know all the principles of law. You should read day-to-day reports of law. You should get accustomed yourself to the changes in the law. You should read new laws, new reports, new acts which come into force. You should understand the judicial principle as to what do you mean by precedents of law. What is burden of proof? What is relevancy of fact? What is irrelevancy of the fact? What are admissions, confessions, dying declarations? Unless you know these basic principles, it would be highly impossible or difficult for you to be a good criminal lawyer. A good criminal lawyer, in fact any lawyer, should develop all these habits. Nowadays, the lawyers want quick money. Within a span of 6 months, they want to buy a Mercedes car. This is the trend. They want shortcuts. They want to earn quick earnings, earn money quickly. You should have patience. This is a profession where the patience is required. Probably this is a profession where the gestation period is much more compared to the other professions. That's the reason the initial years which we put on in the profession to develop ourselves as a lawyer would help you to mark you as the best lawyer amongst lakhs of people. When there is a competition, it is expected that you would mark your presence by delivering the goods. And by delivering the goods means your competence should be reflected. And your competence will be reflected when you inculcate amongst yourself all these good habits as to how you are going to be a good lawyer. Start reading. Reading doesn't mean only CRPC, IPC or Evidence Act or BSA or BNS or BNSS. A lawyer is required to read the books on all the subjects. Psychology, economics, politics, political science, medical jurisprudence, magazines, newspaper, anything in the world, you should go on reading. What is expected of law? That he should be alert enough to immediately take a decision and answer or retort to the question which has come before him. The alertness, the quickness which will distinguish you from the other lawyer. You should be able enough to answer the question raised by the other side. You should be able enough to tackle the law point raised by the other side. You should be able enough to answer the question put to you by the court of law. And this confidence will be based on what? On the hard work which you have put on. So read all these aspects of law. Anything is possible, you can read. One doesn't know what subject will come across when you are conducting a criminal trial. For example, like medical jurisprudence. You read medical jurisprudence. You are not a medical officer. You read books on handwriting experts' opinion. You are not a handwriting expert. You are not an investigating officer. But the time will come that you have to overpower the witness who is expertise in his own field when you cross-examine that particular witness in the court of law. So unless you have that capability to cross-examine that person, it will not possible for you to demolish the evidence of that person. So before preparation, you should see that you are well with this, you are capable of handling the situation in the criminal court. The doctor is an expertise, but you should put him to such question that it was not possible to kill a particular person by a particular weapon which is used in the crime. Isn't it? Similarly, handwriting expert, you are not handwriting expert, but study handwriting, read books on handwriting and put several questions to the witness. And I have seen the cross-examinations conducted by several eminent criminal lawyers, which actually helps in demolishing the prosecution case. Therefore, ultimately, a successful criminal lawyer would be that person who is skilled enough to conduct the trial, criminal trial before the court of law. Therefore, once you master these abilities, various aspects, that will give you confidence to go and conduct the trial before the court of law. So, basic principles of criminal jurisprudence you master. What do you mean by burden of proof? What is the cardinal principle of criminal jurisprudence? Who is required to prove the prosecution case? What is mentioned in 102 of the Evidence Act, 105 of the Evidence Act? What is 106 of the Evidence Act? Whether hearsay evidence can be proved in the court of law? What are contradictions? What are omissions? How contradictions are required to be proved? How omissions are required to be brought on record? How to contradict the witness? How a hostile witness can be dealt with? These are the basic things which you have to understand before you conduct the criminal trial. And therefore, once you develop these habits of understanding, reading, putting your efforts, reading the judgments, distinguishing the judgment, distinguishing the judicial precedents, then you will be able to deliver the goods before the court of law. And a lawyer, it's not only that your acumen which will count, it also counts as to how you behave yourself in the court of law, how you present yourself in the court of law, how you are dressed up in the court of law, how you pursue the court of law, how you present yourself before the court of law, how you argue the matter before the court of law, what sort of language you are using before the court of law, how submissive you are, whether it is necessary to be aggressive in this profession, or whether you are required to strike a balance between slight aggression and being submissiveness. These are the important aspects, finer intricacies, which every one of us will have to first develop before conducting the trial. So unless first you prepare yourself with all these aspects, then you prepare yourself with the criminal trial before the court. No browbeating. The topic is about preparation of trial, but this is also important because before you become a successful criminal lawyer, these are the tenets which everybody should know. And my experience in the court of law as a judge, I have seen that many lawyers were lacking these aspects. So no browbeating, no fighting with the court, not making faces with the court, using a correct language before the court of law. Because earlier also I have said in some speeches that nowadays those WhatsApp languages are also used. That yep, nope, and all sorts of things. Even the judge doesn't like you saying yeah. Yeah is not a language which you are required to use in the court of law. Yes, no, obliged, deeply obliged. And the judges follow what the lawyer wants to say. Sometimes the lawyer says, I have not made myself clear. That means the judge has not understood. But the lawyer who put it in such a way that, Lordship, I have not made myself clear. That means I want to make it clear whether probably you have not understood what I want to say. That I used to understand what the other side wants to say. But that's a way, and that's the right way of putting it. You can't say that you have not understood, you don't know law. Can you say it to the judge? As a guardian judge, I used to receive several complaints that the lawyers are fighting with the judicial officers in the mafiosos because the application is rejected. Accept it. One rejection is not going to spoil your entire practice. Accept it gracefully. You will get satisfaction when you will feel that you have put on 100% in a matter because you are prepared with the matter. Winning or losing doesn't matter. What is expected? Sometimes your client would expect that you have tried your level best. Never go unprepared in the court of law. Be always prepared in the court of law. Not only about the matter which is before you, but about the principles of law, as I have said. One doesn't know what question would crop up when you argue the matter. One doesn't know what judgments the other side is going to bring before you, using it against you. How you are going to distinguish those judgments? Plus binding effects of the judgment, effect of Article 141 of the Constitution of India, effect of larger bench judgment on the lower strand judgments. What do you mean by precedents? What do you mean by per incurium? These are the things we must all know. And every lawyer must read Constitution of India. It's not that only you will read some provisions of Indian Penal Code and go to the court of law and say that this is 302 or so and so, end of the matter. No. You should have that hunger of learning new laws, learning new interpretations, and keeping track of law reports, new judgments. It's only then you will be a successful lawyer. Whether the judgment is binding, even if the other side brings judgment, you should be able to distinguish them. They are not applicable in the facts of this your case. So these are certain basic elementary things which all of us should know and develop among self when you are going to be, if you want to be a successful lawyer. Criminal trial. What is criminal trial? There is no definition of word trial in the code. But that's the definition of inquiry in the code. And the definition of inquiry is mentioned that inquiry is not a trial. But you won't find any definition of the word trial. But there are judicial pronouncements where the word trial has been explained or tried to be explained by the court of law. We say that so-and-so has been tried for offense under 302, so-and-so has been tried for an offense under 326, so-and-so has been tried for an offense under 307. So what do you mean by tried? Trial is a judicial process of finding out the truth from the evidence which has been laid before the court of law by either party. So trial is a fact-finding, is a process of finding out the truth as to whether a person had committed an offense or not committed an offense. Whether he is guilty or not guilty of commission of offense. If he is guilty, he should be punished. If he is not guilty, he should not be punished. How to find out that? So that process will be based on the evidence put forth by the prosecution and the opportunity given to the defense to demolish that evidence by effective cross-examination. Or also, the defense has gets an opportunity to lead the defense evidence, as you all know, being criminal lawyers. So based upon the facts, material, documentary evidence or oral evidence which led before the court of law, the judiciary, the court will find out the truth. That process is a trial. Criminal trial is for what? To determine whether a particular person has committed an offense or he has not committed an offense. What is crime? Crime is an act which is punishable by the law. A crime is an act, is an offense which is mentioned in the Indian Penal Code or Bharatiya Nagarik Shastra. So somewhere a particular act has been defined as an offense which is tried before the criminal court. And the court will determine whether a person has committed an offense. So when a criminal trials come before you, what you will do? I need not expect to, there are many criminal lawyers, seasoned criminal lawyers here, they know. Because for me, I am also learning from all of you, and every day I have been learning about the intricacies of law. It's not for them, as to who all know are experts in the criminal law, but for some juniors. So ultimately, a person commits a crime that will be determined whether he is guilty of the offense by the criminal court. And criminal trials are not only for the penal offenses under the IPC or BNS, also for the other offenses like Prevention of Corruption Act, Food and Drugs Act, various criminal acts are there. Negotiable Instrument, Section 138 of the Negotiable Instruments Act. So when a person comes to you and you are a lawyer and you have to conduct a criminal trial, what would you do? If you don't know basic thing, you will be at sea. You won't understand what is to be done. You won't understand where to go, where to start and where to stop. And you will be confident if you know the basic principles. If you have experience of conducting trial, if you have sat in the court and watched others people conducting cross-examination, you have joined some senior and studied law with the senior. So when first time a criminal trial comes before you, all these questions are going to haunt you. So to avoid this sort of situation, you have to master all those factors which I have told you. Nowadays, some juniors directly from the very first day they want to earn money and they start appearing in the court of law. That system of Gurukul is there since ages and it should continue forever. You have to join some senior. Ultimately, your Sri Ganesha of law is being taught to you by the senior. Experience in how he drafts the matter, how he argues the matter, how he conducts trials, how he has cross-examined. All these aspects you have to sit with him and study him, watch at him and study the law. When you don't have matter, that time also you should go and sit in the court of law. Observe other seniors how they are conducting trial. Observe other seniors how they are arguing the matters, how submissive they were. Although the court is against them, how they have persuaded the court to accept their point, which requires skill. Sometimes the court also doesn't know the provisions of law. It is for the lawyer to enlighten the court on certain aspects of law. Some issues arise in the court, it depends upon the interpretation of law. It is either this way or this way. The skill of the lawyer would come into picture as to how to interpret a particular provision of law. How to read the judgment which is relied upon by that lawyer. How to read the ratio which has been relied upon by the advocate from the judgment which is cited before. So how would you know this? You should also understand something called a ratio decidendi and obiter dicta. हे बेसिक गोष्टी आपण शिकलो नाही तर इम्पॉसिबल आहे. सगळ्यांना वाटतं आपण जायचं, बेल ॲप्लिकेशन चालवायचं, पैसे घ्यायचं, घरी जायचं. तसं नाही. चांगला वकील व्हायचं असेल तर हे सगळे बारीक सारीक न्युअन्सेस बेसिक प्रिन्सिपल आपल्याला शिकण्याची गरज आहे. रेशिओ डिसेंट काय करायचं आपल्याला बेल ॲप्लिकेशनमध्ये त्याचं काय गरज नाही. दॅट इज द अंडर. प्रेसिडेंट काय करायचं जजमेंट कोण बघत नाही. There are some lawyers who only argue bail matters. Quick money, local disposal. वेगवेगळ्या मॅटर. अँड द मोस्ट डिफिकल्ट अकॉर्डिंग टू मी इज द क्रिमिनल ट्रायल. क्रिमिनल ट्रायल चालवण्यासारखं कठीण काम नाही. आणि ॲपेलेट कोर्टात द लॉयर्स ओनली आर्ग्यू what is being argued before the trial court. If the cross examination is not conducted effectively by the trial lawyer, nobody can help you in the appellate court. It's only how the defense has been led by the trial court by a trial lawyer, it is going to help you in the appellate court. Otherwise it is impossible. Things can't be improvised in the appellate court. Things can be interpreted as it is, which were put forth by a defense lawyer before the trial court. And I must also say that criminal trial doesn't mean only the defense side, maybe most of you may be, but prosecution also. Trial means one side is led by prosecution, other side is led by the defense. Prosecutor has to study the case, has to read the charge sheet, decide which witnesses he is going to examine, address the court on that, open the case before the court of law, then the charge would be framed. If there is no case, he will be discharged, then the evidence will be led. The witness for prosecution, his examination will be recorded, which will be led by the prosecution. The defense lawyer would cross-examine. All oral and documentary evidence will be before the court. Then the 313 would come. If the defense want to examine, then the skill of again defense lawyer would come as to which witness is to be examined. And then end of the trial. So right from the beginning till the end, you are on your toes. You have to be alert enough. One silly mistake can cost you the fate of your client. Some application, ridiculous application made before the court of law, some admitting certain document which ought not to have been admitted, not cross-examining the witness which should have been cross-examined, cross-examining the witness to such an extent that it was not called upon and damaging the case. The most important factor in the cross-examination is that the lawyer should know where to stop. If you don't know where to stop, that will be the end of the matter. One silly mistake, then the lawyer feels that I want to cure that mistake. Then the second mistake, then he again causes damage to the case. Then the third mistake, and the result is completely massacre in the criminal court. What is expected of you is to know as to what cross-examination, what questions to be put to the witness. And cross-examination, my frank opinion, by reading books, you can't cross-examine. Cross-examination is you should have personal experience and where the skill of a person is involved. You have to be there in the court. You have to experience, you have to conduct cross-examination. Then only you will be well versed and will be expertise in conducting cross-examination. There are some books on cross-examination. Maybe you may get some idea. But those examples you may not come in your case which you are handling. Every case depends upon the facts of the case. Every case depends on the nature of the evidence before the court. Every case depends upon the number of eyewitnesses before the court. So if you know all these aspects, then you will be confidently appearing before the court. That's the reason you see some senior lawyers who are conducting trials, the enormous confidence which they have when they are before the trial court. And their confidence, in fact, the judges are also influenced by the confidence of the lawyer who are are conducting trials before the criminal courts. So after accomplishing all this aspect, when a matter comes before you, you have to study the matter, master the facts, as I have said, know the law, apply the law, see the weaknesses in the prosecution case, and think of the valid defense which you are going to raise in this particular trial in advance. Maybe things may demand that at a particular stage you need to change the defense also. It depends. But otherwise, you just can't rush to the court, take up the papers and just plead some defense. You have to plan yourself. Trial म्हणजे काय असं खायचं काम नाही आहे. You have to plan yourself. प्लॅन करायचा, व्यवस्थित पद्धतशीरप्रमाणे अभ्यास करायचा, and then you think what defense. Because I have seen some cases where cross-examination goes to such an extent that even motive is also proved by the defense. The prosecution is not interested in proving motive. Prosecution is not has no evidence to show the intention. But sometimes the lawyers go to such an extent by cross-examining the witnesses that the evidence, the intention, motive, circumstances, everything is brought before the court of law. The problem is that नवीन मुलं, of course, they should come up unless they practice. त्यांना म्हणजे लाईफमध्ये असं ऑपॉर्च्युनिटी मिळाली तरच वरती येणार. आय हॅव नो डाऊट. पण थोडं दुसऱ्याला विचारायचं, सिनियर लोकांना विचारायचं, त्यांची मदत घ्यायची, अभ्यास करायचा आणि केस चालवायची. नाही काय ब कडं येत नसलेल्या लोकांनी सुद्धा केस चालवले की मग त्याला कोणीही वाचवू शकत नाही त्या पक्षकाराला. दिस इज नॉट टू डिस्करेज यू. आय एम ऑल्सो अमंग्स यू, आय एम ऑल्सो लाईक यू. पण हे लक्षात ठेवावं म्हणून मी सांगतो. मला काय पूर्ण लॉ येतो असं नाही, आणि असं कोणी म्हणू शकत नाही की मला सगळा लॉ येतो. ज्या दिवशी एखाद्याला वाटेल मला पूर्ण लॉ येतो, संपला. लॉ हा असा फील्ड आहे की नो बडी कॅन क्लेम दॅट आय नो एव्हरीथिंग अबाउट द लॉ. And according to me, the most difficult law in this act is the Indian Evidence Act. आयुष्य काढलं तर तो संपूर्णपणे कळणं कठीण आहे असं माझं प्रामाणिक म्हणणं आहे. It's very difficult to understand the finer intricacies of the law of evidence. There are various aspects of it. सेक्शन वाचून कळण्यामध्येच आपल्याला कळेपर्यंत ट्रायल संपेल. What is admissible, relevancy of the fact, fact in issue, proved, disproved, त्याचा अर्थ काय, proved काय, disproved अर्थ काय, confession, whether they are admissible in evidence, confession before the police, confessions under section 164, statement under section 164 of CRPC, आता बदललेलं आहे नवीन ॲक्टमध्ये. Value of hearsay evidence, dying declaration, identification parade, हे आपल्याला कळायला पाहिजे. Dying declaration law, you must read judgments, the law keeps on changing. The law is that even a dying declaration which inspires confidence is sufficient to convict. But if there is a doubt, then conviction can't be based solely on dying declaration. Correct, isn't it? आता लॉ मध्ये बदलला की earlier there was some judgment which say that the endorsement of the doctor is necessary on the dying declaration. That has gone away, diluted by the court now. Even in the absence of the endorsement of doctor, he is in a fit condition to record a statement. Even that document can be relied upon. So these principles of Evidence Act, what is admissible, what is not admissible, which is relevant, which is not relevant fact, हे आपल्याला आत्मसात करण्याची गरज आहे. ह्याच्यावरती आपल्याला मास्टरी करायला लागेल, तरच you will be a successful lawyer. We can convince the court that this is not admissible under the Evidence Act. But आपण general public feels, की there was a eye witness to the incident of murder. तरी पण तो सुटला कसा? कसा सुटला? लोकांना वाटतं की आरोपीने सांगितलं होतं पोलीस स्टेशनला जाऊन की आय हॅव कमिटेड मर्डर. सुटला कसा? दॅट स्टेटमेंट हॅज नो व्हॅल्यू in the eyes of law. That is hit by the principles of Evidence Act. You read section 25, 26, 24 of Evidence Act, 27, 32. हे रोज वाचलं पाहिजे. हे तुम्ही रोज वाचलं नाही तर मग कठीण काम आहे. क्रिमिनल लॉयरला ह्या सगळ्या येणं फार गरजेचं आहे. And when you conduct a criminal trial, you should also know the other aspects of the investigation, how investigation is required to be done, who has done the investigation, what are the other aspects of the investigation. All these aspects also you are required to know. Who can set the law into motion? Anybody can set the law into motion. That is, everyone, except in some cases where a question of locus arises, where a particular person only can set the law into motion. Otherwise, anybody can set the law into motion. So, investigation starts with FIR. Now, under the new act, there is some preliminary inquiry is also contemplated. That before registering FIR, preliminary inquiry can be done within a period of 14 days. That was not so in the earlier legislation. So, investigation, then recording statements of witnesses under 161, recording confession or statement under 164. What is the value of statement of 164? And then filing report under section 173 of CRPC, old enactment. Then taking cognizance, whether the court had taken cognizance of a case. This we have to know. The court had jurisdiction, whether the cognizance is rightly taken. And whether before you start the trial, there is a compliance of section 207 of CRPC. That the accused is entitled for all the material which is relied upon by the prosecution. Then you read that material and conduct trial. So the main skill, at the cost of repetition I am saying, will be on how you are conducting cross-examination in the court of law. And there are various types of trials. Sessions trial, summons trial, summary trial, warrant trial cases before the magistrate. तो तुमच्याकडे जेव्हा केस येते ही कुठली टाईपची आहे? सेशन ट्रायल आहे का, की वॉरंट ट्रायबल केस आहे का? That based on the police report, that which is based otherwise than on a police report. कारण तुमचा stand will depend upon what type of criminal trial you are going to conduct. Summary trial. तर समरी ट्रायलचा अर्थ काय? समन्स ट्रायबल केसचा अर्थ काय? ती कधी करतात? कधी कन्वर्ट होऊ शकते का केस? ह्या सगळ्या गोष्टी आपल्याला शिकणं फार गरजेचं आहे. ऑफकोर्स एक बेनिफिट आपल्याला असते, वी कॅन, इट्स नॉट दॅट एव्हरी डे यू शुड नो एव्हरी एस्पेक्ट ऑफ द लॉ. बुक्स आर देअर. व्हॉट इज रिक्वायर्ड दॅट कंटिन्युअस रीडिंग ऑफ द बुक्स अँड बी इन टच विथ द बुक्स. And I am saying again that reading is the most important aspect. Henry Ford had said that once you stop reading, you become old. If you continue reading, you never become old. You are as young even at the age of 80. तर ह्या वेगळ्या वेगळ्या टाईपच्या ट्रायल कशा चालवायचं ह्याचं एक प्रिपरेशन करावं लागेल. लाईक पोलीस केस असेल, प्रायव्हेट कंप्लेंट असेल, वॉरंट केस other than based on the police report, whether there is a provision of discharge झाला तर परत ट्रायल कंडक्ट करायचा प्रश्न येत नाही ना. Under the old acts, there were provisions of section 245, section 239, section 227, all relating to the discharge. ह्या सगळ्या गोष्टी म्हणजे यू हॅव टू मास्टर दी प्रोसिजर कोड, दी इंडियन एव्हिडन्स ॲक्ट अँड अ पिनल लॉ. आणि फील्ड एवढ्यावरती थांबत नाही. देर आर अदर ॲक्ट्स ऑल्सो विच आर cases are conducted before the criminal court, in magistrate courts or in session court or special courts like NDPS cases or Prevention of Corruption Act cases, and cases which are conducted before the magistrate like 138 cases, and all those triable by the magistrate. But principal committal म्हणजे काय, which case is required to be committed, and the right of the accused. If you are appearing for the accused, you should know all the rights of the accused. तुमच्याकडे केस येते तेव्हा पहिली गोष्ट what you have to determine is what are the rights of your client. Unless you know the rights of your client, you won't resort to the remedy. Where there is a right, there is a remedy. There is a saying in the torts, ubi just ibi remedium. Where there is a right, there is a remedy. The Constitution and the Code provides enormous rights to the accused who is facing trial, right from the time of arrest. Have you read Article 20, 22 and 21 of the Constitution of India? Article 20 provides various rights. No person can be convicted for an offense which was not in existence at the time when the offense was committed. Suppose some offense comes into picture subsequently, he can't be convicted. No punishment can be provided which is larger at a subsequent stage and which was minimum at the earlier stage. Double jeopardy. And no person can be compelled to give evidence against him, self-incriminating evidence against him. These are the cardinal principles embodied under Article 20. Article 22, grounds of arrest. Person should be produced before the court of law within 24 hours. Similar provision you will find even in the Code of Criminal Procedure also, that he is required to be produced within 24 hours. तर हे सगळं झालं होतं का? Whether these procedural safeguards are complied or not, that we are supposed to know. And is there is a provision of default bail also under 167 of the old code. Similar provision is also there in the new code, but there is some variation. So lawyer has to be, clientला माहीत नसतं की काय 60 दिवस झालेत की 90 दिवस झालेत. You have to be on toes that 60 days are completed or 90 days are completed, depending upon the punishment which is provided under the law. So हे सगळं this is all expected from whom? Us as a lawyer. How to calculate the period of 60 days or 90 days. I had an occasion to deal this point. There is one judgment, whether it is from the date of arrest or from the date of first remand. And the law, constitutional law, it should be from the first date of remand. There was some decision which said that it is from the date of arrest. But it's settled law that it's from the date of first remand. And what is required, you have to apply for bail. If you don't apply for bail and a charge sheet is filed, the rights get defeated. If you apply and then charge sheet filed, it is indefeasible. हे आपल्याला माहीत पाहिजे. पक्षकार आपल्याकडे एक कागद घेऊन येणार. One piece of paper will come with one piece of paper, correct? And from one piece of paper, we can convert it into writ petition of 100 pages. This is going to happen when तो तुमचा स्वतःचा कायदा चांगला असेल तर, तुमचा लँग्वेजवरती कमांड असेल तर, तुमचा गाढा अभ्यास असेल तर, तुम्ही सगळे प्रिन्सिपल्स ऑफ लॉ आणि त्याला काय पाहिजे पक्ष करायला हे तुम्हाला माहीत असेल तर, कायद्यात त्याला रेमेडी काय अवेलेबल आहे हे तुम्हाला माहीत असेल तर, if you know all this, then only you will be able to convert that one page into 100 pages. आता आपल्याला काही जण म्हणतात क्रिमिनल ट्रायल कोर्ट लॉयरला ड्राफ्टिंगची काही गरज नाही, कारण फार तर फार एक्झाम्शन ॲप्लिकेशन असतं किंवा काय डॉक्युमेंट ॲडमिट करायची की नाही ॲडमिट तेवढं एक ॲप्लिकेशन असतं, किंवा रिकॉलिंग द विटनेस फॉर द क्रॉस एक्झामिनेशन तसं असतं, बाकी काय नसतं. पण असं नाही, ड्राफ्टिंगवरती प्रत्येकाने भर दिलाच पाहिजे. ड्राफ्टिंग इज द मोस्ट इम्पॉर्टंट ॲस्पेक्ट ऑफ आवर प्रोफेशन. ड्राफ्टिंग येत नसेल तर माझ्या मते यू आर नॉट अ कम्प्लीट लॉयर. म्हणून कॉन्स्टिट्यूशन वाचा. कॉन्स्टिट्यूशन इज द पॅरेंट लॉ. ऑल द लॉज फ्लो फ्रॉम द कॉन्स्टिट्यूशन. आपण अल्ट्रा व्हायरस कॉन्स्टिट्यूशन कधी म्हणतो? वेन द लॉ, न्यू लॉ इज अगेन द कॉन्स्टिट्यूशन, अगेन द बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन. तर कॉन्स्टिट्यूशन वाचलं पाहिजे ना. आर्टिकल 14, 19, 20, 22, 21, 2 to 6 if you are practicing in High Court, 2 to 7 the supervisory jurisdiction. आता क्रिमिनल ट्रायल चालवताना काही एक इश्यू झाला, that the witness was not cross-examined, you are not present in the court. So you make an application for what? Recalling that witness. Correct? You make an application for recalling that witness for the purpose of cross-examination. Generally, I suppose the courts grant such application because of fault of the lawyer or his difficulty, the client should not suffer. But if the court rejects your application, what is the remedy to you? In a session trial case, you will go to High Court. मग तुम्ही हायकोर्टात गेला तर हायकोर्टामध्ये कुठल्या सेक्शन खाली जाणार हे माहीत नको. त्याच्यामुळे आपण असं म्हणत नाही की मी ट्रायल कोर्टात आहे तर मला फक्त ट्रायलची प्रोव्हिजन आणि 225 to 237 परची प्रोव्हिजन एवढीच माहीत पाहिजे, तसं नाही आहे. whether that application can be moved under 2 to 7 of Constitution or 482 of Code of Criminal Procedure. What is the remedy under 2 to 6? What are the writs? Writsच्या बद्दल तर आपण generally we are not bothered unless we are practicing in writ court. There are various types of writs. आलं लक्षात? So as I have said की lawyer म्हणजे फक्त काय एक स्पेसिफिक याच्यामध्ये सर्कलमध्ये वाईड अँगल आहे. लॉयर म्हणजे वाईड अँगल. ही नोज एव्हरीथिंग. नॉट दॅट जॅक ऑफ ऑल ट्रेड्स अँड मास्टर ऑफ नथिंग लाईक दॅट, बट ही नोज, ही हॅज ओव्हरऑल नॉलेज ऑफ एव्हरीथिंग अँड ही इज द पर्सन हू इज कॅपेबल ऑफ डिलिंग विथ द सिच्युएशन. आता आपल्याला केसेस संपत नाही, लॉयर्स लांब लचक करतात किंवा कोर्टालाही जनरल पब्लिक शिव्या घालतात, लॉयर्स नाही शिव्या घालतात. पण काय अडचण आली तर कोणाकडे जातात? लॉयरकडेच जातात ना. त्यांना कठीण परिस्थितीतून कोण बाहेर काढतो? लॉयर काढतो. पण त्यांचा जो तुमच्यावरती विश्वास आहे तो विश्वासाला तुम्ही पात्र ठरले पाहिजे की नको? आणि त्या विश्वासाला पात्र कधी ठरणार? जेव्हा तुम्हाला काय जाईल. ह्या सगळ्या गोष्टी आपल्याला प्रत्येकाला आत्मसात करण्याचं करा. आणि असं हे सगळं लक्षात घेऊन मग क्रिमिनल ट्रायल चालवा. एव्हिडन्स रेकॉर्ड करत असताना बऱ्याच वेळा बघतो ते की आपण नसतो हजर कोर्टामध्ये आणि कधीतरी कुठून तरी अचानक येतो आणि तिथल्या तिथे बघतो आणि क्रॉस चालू करतो, चला चालू. त्याचं काही एक्सपर्ट असतं त्यांना ते कॅन डू इट, बट मोस्ट ऑफ द पीपल दे आर नॉट इन अ पोझिशन. बीइंग इन अ कोर्ट अँड नोईंग हाव the demeanor of the witness, what he has deposed, what are the words which has come on record, whether the evidence is rightly recorded or not, हे तुम्हाला कोर्टात बसल्यावरती कळणार. आणि मग then you start cross examining. and even 313 also sometimes bears importance. कधी कधी प्रश्न येतो की what was your ultimate defense? Of course, in 313, the questions which are not binding on you. It's not necessary or mandatory for you to answer each and every question. But if you answer in a wrong way, or if you answer that last question in 313 as to what you want to say, and तिथं काहीतरी वाटोळं केलं तर मग तिचं काय कोण तुम्हाला वाचू शकणार नाही. Because that also sometimes is considered as a defense. The whole object of 313 is to give an opportunity to the accused to defend himself and to explain the circumstances which are used against him. इजंट इट? सो तिथंसुद्धा आपण असं झोपून राहू शकत नाही. यू हॅव टू बी अलर्ट. अँड देन आर्ग्युमेंट्स. तुम्हाला डिफेन्स विटनेस पाहिजे तर डिफेन्स विटनेस एक्झामिन करा. दे विल बी क्रॉस एक्झामिन बाय द अदर साईड. अँड सर्वात महत्त्वाचं जसं मी सांगितलं की ओमिशन्स आलेली आहेत ती रेकॉर्डवरती आणायला पाहिजे. आय केम अक्रॉस अ केस रिसेंटली when I appeared in one matter before the apex court. 75 वर्षाची बाई. So she was tried for an offense under 307 and the prosecution case was that the daughter-in-law was burnt, attempted to be killed. Her husband also was an accused. In the statement under 161, the eyewitness have stated that the husband had poured kerosene and burnt her. And the other accused, that mother-in-law, was present at the scene. पण म्हणजे कोर्टात काय सांगितलं की हजबंड उभा होता नुसता अँड मदर-इन-लॉ हॅड poured the kerosene and burnt her. Now it was the duty of the lawyer to prove this omission. So in the cross-examination, there was not even a single question on this. And that 75-year-old lady was convicted for 307 and husband was acquitted. So matter went before the Supreme Court. The appeal is pending, but the court has granted bail. But this is whose mistake? It's our mistake. आपलं चुकलं त्याच्यामध्ये लॉयरचं. आता तिथं विचारला नाही प्रश्न तर सुप्रीम कोर्टात नाही विचारू शकत तुम्ही. Appellate court doesn't have power. The damage is already done and damage has gone to such an extent that it can't be cured. This type of damages can't be cured. That is the reason a trial court's lawyer. Okay. So this is where, as I have said, you have to be always alert in the court while dealing with the criminal trial. ह्या सगळ्या गोष्टी तुम्ही लक्षात ठेवलं पाहिजे ॲज अ क्रिमिनल लॉयर. आणि सबमिसिव्ह असलं पाहिजे कोर्टामध्ये. बी सबमिसिव्ह इन द कोर्ट ऑफ लॉ. उगाच असे काहीतरी विचित्र कपडे घालून यायचं, पॅन्ट लावायचा नाही, गाऊन घालायचा नाही. जिथं काही ठिकाणी गाऊन घालायची गरज नाही, आय कॅन अंडरस्टँड. कोट कसल्याही कलरचा घालायचा, केस कसे तरी वाढवून यायचं. ते याच्यामध्ये लिहिलं नसेल आपल्या ॲडव्होकेट ॲक्टमध्ये, पण यू हॅव टू बी प्रेझेंटेबल नो. आणि तुम्ही खोटं बोलला तरी कोर्टाला कळतं, वारंवार खोटं बोलला तरी कोर्टाला कळतं. जेव्हा तुम्ही वारंवार खोटं बोलता हे कोर्टाला कळतं, कोर्टाच्या मनात हा माणूस ह्याचं काही खरं सांगितलं तर ते खोटंच वाटतं. मग सो डोंट क्रिएट युअर इमेज दॅट you are all the time misleading the court. It so happens that once you have created that image, the judge sometimes has discretion to pass some order in your favor that he will not exercise. After knowing that, you have that tendency of making false statement or misleading the court. Correct? तो ह्या सगळ्या गोष्टी पण म्हणजे तुम्ही कसं राहताय, कसं आर्ग्यू करताय, कसं बोलताय, कसं सबमिसिव्ह आहात, कसे तुम्ही तयार आहात कायद्यामध्ये, तुम्ही जजमेंट वाचतात का डे टू डे. डेली जजमेंट बदलत असतात, डेली वाचायचं. आणि रिडिंग जजमेंट्स आय एम टेलिंग यू ऑल्सो इम्प्रूव्ज युअर लिगल लँग्वेज. यू नो दॅर इज समथिंग कॉल्ड अ लिगल लँग्वेज. वेन यू ड्राफ्ट अ पिटिशन, वेन यू आर्ग्यू, you are required to use certain legal terminologies. That is developed when you actually read the judicial pronouncement, various judicial pronouncement. हे वाचनानेच तुमचं तयार होईल. वाचाल तर वाचाल, समजलं? म्हणजे वाचलं तुम्ही तर तुम्ही वाचणार. सो voracious reader, every lawyer has to be a voracious leader. एक काम केलं आणि संपलं असं नाही. आणि थोडं पेशन्स ठेवा. थोडं पैसे मिळायला इथं वेळ लागतात. आता लॉयर पण भरपूर झालेले आहेत, सगळ्यांनाच कसे पैसे मिळतील. पण पैसे मिळण्यासाठी वाकड्या मार्गाने जाऊ नका, सरळ मार्गाने चला. एकदा सरळ मार्गाने तुम्ही नाव कमावलं की तुम्हाला कोण थांबवू शकतं. So preparation of criminal trial, a practical approach is first and foremost thing is that you should be alert and well versed with the provisions of law. मग पुढचं आपोआप येईल. मग त्याच्यासाठी मग बरोबर तुम्ही क्रॉस एक्झामिनेशन कराल तर तुम्हाला माहिती आहे की कितपर्यंत क्रॉस एक्झामिनेशन करायचं, जे ऑलरेडी रेकॉर्डवरती आहे ते ॲडमिसिबल आहे की नॉन ॲडमिसिबल आहे. सो हे सगळं जर तुम्ही इफ यू मास्टर ऑल दिस, आय फील दॅट एव्हरी वन विल बी अ सक्सेसफुल. 12:45 वाजलेले आहेत, पुढचं पण लेक्चर आहे आणि ठीक आहे ना. आय थिंक आय शुड एंड हिअर. दुसऱ्यांनी एकदा थांबवा म्हणण्यापूर्वी आपण थांबवलेलं बरं म्हणून म्हटलं. आता आय होप वॉट एवर लिटल एक्सपिरियन्स आय हॅड आय कुड शेअर विथ यू. आणि मला पण इथं येऊन आनंद झाला. मला म्हणजे ॲक्च्युली आपलं प्रोफेशन असं आहे की आपण डेली काहीतरी शिकत असतो. आपण दुसऱ्याकडून शिकतो आणि आपण शिकत राहायचं कायमचं दुसऱ्याकडून. या प्रोफेशनमध्ये आपण असं कधीच म्हणूया नको की आपल्याला सगळं येतं. थँक्यू व्हेरी मच फॉर पेशंट हिअरिंग मी अँड आय एम थँकफुल फॉर दी अथॉरिटीज फॉर इन्व्हायटिंग मी फॉर दिस टुडेज फंक्शन. थँक्यू व्हेरी.
Indeed, such an intellectual stimulus to all of us. Sir has touched upon all the important topics. We will take a minute. May I kindly request our speaker for today, Honorable former Justice Prakash Naik sir, to kindly felicitate Vikhroli Court Bar Association and its committee members. Sir, this program would not have been possible without the collaborative initiative of different bar associations, and Vikhroli Court Bar Association is one of the bar associations who took part in organizing this event. Please give a huge round of applause. Thank you so much, sir. Thank you so much, all the committee members. Topics related to nuances of criminal law, but it also helps us acknowledge different topics that we do not know or we regularly come across, but we see it in a new light. And Honorable Mr. Prakash D. Naik sir, he's a beacon of such a huge knowledge. I think his speech was synonymous with an encyclopedia. He has touched so many wide variety of topics in his given stipulated time. It makes me wonder how does he draft his speech like so eloquent. Thank you so much, sir. We have with us all the committee members of Vikhroli Court Bar Association to grace the stage. Thank you so much, sir. Thank you so much, all the committee members. We are deeply privileged to have you here.